Thank you, Mr. Chairman and honorable members of the committee. My name is Marissa Janssen, and I'm legal counsel at the Rhode Island Commissioner for Human Rights. We are here in strong support of Bill 2475. This bill, among other things, would close loopholes that allow a defense of claims for wage discrimination and expand those bases on which all wage discrimination and differentials are prohibited. Currently, a complainant that came before the commission and alleged sex discrimination and based on the terms and conditions of their employment would have to prove virtually that they have the same exact comparator at their work. That is virtually impossible and almost impossible to overcome as a complainant at the commission. They would have to have somebody that had the same number of years there, somebody. If they were a white woman, they would have to find a white man, for example, that had been there for the same amount of years, with the same amount of experience, with the same amount of education, and then prove that they were comparable to the same amount of work and are entitled to the same amount of money. One part of this that is very difficult is that that person may not exist. So that would be an insurmountable hurdle to that complainant. Additionally, the anti-discrimination laws are put in place so that discrimination does not happen. Concerns that may be brought about regarding shifting burdens of proof onto employers are merely distractions. Anti-discrimination laws are not subject, as previously mentioned, to 3 years to change your business practice. If you're discriminating, you need to change your processes and what's happening in your environment immediately. This would just be a new bill that would provide that employers need to recognize that there are problems and they need to change them within their own organization. Only they can do that. Only they know who has the same employment, who has the same education, who's producing the same amount of work, and that is their duty if this law passed. The DLT promulgating a regulation regarding the comparable work issue is also something that could be, if this law passed soon, could be dealt with because all administrative agencies must re-promulgate their rules and regulations before December of 2018. So that actually is something that could be addressed within the time and within a very reasonable time if this bill was to be passed. The commission would have joint jurisdiction, which we are more than happy to have, because right now this allows for an objective standard to review. And as of right now, there is no objective standard because there is no one person that is exactly like you, that looks exactly the opposite of you, that you can say, this man is 38 years old, went to law school at this time, went to this exact same law school, but does the same exact work at the Commission for Human Rights and is an attorney, and therefore should be paid the same. It's virtually impossible. So this is an objective criteria set out to make sure that people are paid the same for the same work. So the Commission strongly supports this bill.
Thank you. Senator. Marissa, it's almost like Groundhog Day. We were having this discussion last night. As a father of twins, girls, women, I think you know where my intent is and where I fall on the intent of this bill. My concern as one of the primary enforcement agencies that will be handling this is the standard by which an employer can successfully defend an accusation of unfair wages. And so there's a three-pronged test, as you know. But one of the prongs, there are 4 separate categories of exemptions, but the 4th, which talks about a bona fide factor other than race. And this is purely from a drafting standpoint. I'm focusing on page 3, line 5, and it says that, so the 4th rung is a bona fide factor other than race or color, yada, yada, yada. And then it says A, and the employer demonstrates the following factor. A, is not based on. So do you have a problem merely from a draftsmanship standpoint. We clearly support the intent of this legislation 1,000%. But as I said last night in judiciary, I want to say tonight in labor, that we want to be able to enforce it and not meet a court challenge based on poor draftsmanship of the bill. Do I make sense when I ask that question?
I'm going to do my best. I think I understand your question. So an employer would be able to have a defense if they showed that a wage differential is permitted if it's based on something such as merit system, or somebody is making, producing more or better quality.
Excuse me, forget that part.
Yes, of course. The next section.
Let's go to item 4.
Line 4.
The exemptions. It says, maybe I can make more sense.
Oh, subsection 4.
The fourth exemption
Yep.
says a bona fide factor other than race or color, religion, sex orientation, etc. And then it says, this factor shall apply only if the employer demonstrates what is essentially the following 3 factors. And the first factor says that it's not based on discrimination. So it almost says he's not discriminating or she's not discriminating, and the first prong says, well, they're not discriminating. It's just from a draftsmanship standpoint, that's all. Excuse me? That's the chair's prerogative. Sure. I'm sorry, but I want to get it right. That's
No, I appreciate what you're asking. It's the derived from that's different, so.
Yes. Yes, exactly. So,
Okay.
yeah, so the bona fide factor would be something such as education, training, or experience. So if somebody was a man that had worked in something such as, say, sales for 10 years, that would be something like experience that would account, or training, certifications if they were in an MS sales, for example. However, the factor shall only apply if they demonstrate that it was not based simply on the fact that they were male, is what I believe the intent of the drafter was.